Yeah, thank you very much, Gab. Good morning, Chair Melanie, Commissioner Jojo, our friends from TAF, and everyone for joining us. And thank you for joining us this morning. I'm a bit concerned about my connection, so please tell me if my connection is poor. I'll just turn my video off in case that happens. All right, so today we're actually having our town hall meeting for CLEP compliance. So before anything, let me just emphasize that today what we have is almost an informal gathering, although virtually, with our stakeholders with regard to discuss their concerns with regard to CLEP. As the chairperson touched upon, there are existing concerns and challenges that some schools face, and the LED is very aware of that, and we're looking for ways to help you out. Uh, and this town hall meeting, since it's a bit more informal, please, we are here just to answer your questions. No questions are invalid, and all are important to us. But to facilitate the discussion, I will be showing questions on screen just to guide the discussion along. These are based on the frequently asked questions we receive from our stakeholders about a variety of matters on CLEP, but also some of the FAQs identified and answered by the Supreme Court. So hopefully with this discussion, you'll be able to understand better if you do have misgivings or concerns about CLEP. In the same breath, I also invite my fellow CLEP team members, Commissioner Jojo, and other colleagues, if you want to provide additional context and information to answer our stakeholders' questions, please feel free to do so. All right. So I hope there will be questions that you can ask in the chat box. You can raise your hand and unmute yourself to ask those questions in person. All right. So let's begin. The first topic I'd like to discuss to everyone is the general concept of what limited law practice for students is. Can we go to the next slide, please? Because I think this is the heart of the rule, and also sometimes it may be missed by a lot of our stakeholders, because Rule 138A, the revised Rule 138 really essentially says law students can practice law now. That's the simple essence of it. And yes, they have been doing so in the past through the old Rule 138A, but here it's been strengthened and made systematic across the country. But that's also very important because even if they do have limits, these law students, when they earn or they have the certification, are full-fledged lawyers already, at least in terms of their function. So in terms of difference between the practice of law of lawyers and law student practitioners, the only limit that LSPs or law student practitioners have is what is provided in revised Rule 138. That is, excuse me, that is in relation to their certification, whether it's a level 1 or level 2, they would have certain limitations. And also, they should always be guided by supervising lawyers. And finally, there are specific areas or focus that is allowed under CLEP as the CLEP. But essentially, it is very important that when we look at our LSPs, both for our schools and for our courts, local justice actors, they're looking at applications for the LSPs can be understood better if you read revised Rule 138A. Obviously, things are evolving, and in the future, we may listen and hear jurisprudence on the matter, but definitely, at least from this perspective, revised Rule 138A already provides that outline of limitations. I think Dean Sol has a question already. Thank you, Dean Sol, for being with us. Let me pin that question first and try to answer it a little bit later. Let me just talk about general concepts of CLEP. But yes, what is the difference between the duties imposed upon a lawyer and law student practitioner? Well, your Bible here is revised Rule 138A. And definitely, although they are lawyers, as I mentioned, there are certain limits to it. It's very important because sometimes a student may forget that there is a level 1 and level 2 certification, and both the two certifications do not are mutually exclusive in a sense to each other. Level 2 certification allows for broader functions, and level 1 does not. All right, and now let's look now at the coverage of CLEP. So, and this will relate to the question of being solved. What batch of graduates shall be covered by CLEP? So the Supreme Court has clarified this through its FAQs that only the ones who graduate in 2023, the academic year 2022 to 2023, and then will take the bar starting 2023. Okay, so that would be the two reckoning points that you would want to consider when you are asked this question. So is the student a graduate of academic year 2022-2023? And then the second question is, are they taking the 2023 bar? And if the both answers are yes, then CLEP, then their batch of graduates are affected by CLEP. If you're already a graduate prior to the issuance of CLEP and you did not decide to take the upcoming bar, and this bar refers to 2022 or earlier bars, should they enroll in the CLEP course, they're not required to. It's not a requirement for them to have a CLEP on their transcript if they're taking the bar in 2022, in the year 2022 or earlier. If they've taken the bar, for example, this year, the hybrid bar this year. So we still go back to the reckoning point of graduating in the academic year 2022 to 2023, and then taking the bar starting 2023 and later. And does CLEP apply retroactively? And the follow-up question is, if yes, is it legal to do so? So it doesn't apply retroactively. But here are a few examples of situations that may help clarify the matter further. Next slide, please. There, let me have, yeah, there you go. So for example, in order to take the bar in 2023, how many units or hours of CLEP must they take? Or what is the minimum number of unit or hours of CLEP required of a student in order to take the bar? So the Supreme Court in its FAQ said that at the minimum, schools are expected to provide at least a 2-unit course for CLEP. But this is just the minimum. And look, moving forward, and we've seen this in the revised model law curriculum, that some schools have taken on CLEP and developed it into a course that is more than 2 units. So schools have academic freedom to really provide a more comprehensive, a more long CLEP training for their students, but at the minimum, they only are required to have 2 units. So if the student has graduated 2020 and plans to take the bar 2023, is he required to take CLEP before taking the bar? So the answer is, and Jojo, thank you for also sharing your answer on the chat. The answer is no. So the reckoning point again is that they graduate in 2023. If the student entered law school in the year 2000 and filed their leave of absence immediately and returned in 2020, so it took them 20 years to go back to school, is he required to take the CLEP? So the answer of the Supreme Court in the FAQs is it's a yes. They must take the CLEP. But let's nuance that further, because we have to also refer that back to the year when they will take the bar. So in this context, perhaps the student did not finish their first year, and so when they return in 2020, they would still need take 4 years to graduate law school. So most probably they will take the 2024 bar and graduate in that same year. And so definitely the rule will apply to them, all right? But what the question here really touches upon is, even if there's an intervening period in between the year of admission of a student and the graduation year, like in this case, it will took them 20 years to graduate. But if they graduate by the year 2023 and they take the 2023 bar and onwards, then the rule also applies.
Na yung ginawa, naka-ano?
Sorry? Okay. I think someone was unmuted. But okay. Moving on. So if a student graduated and took the bar in 2019, but did not make it, and he takes the bar again in 2020, 2021, or let's just change the year 2023. Is he required to take the CLEP? No, because they graduated earlier than 2023. So even for those who would be repeating the exam because they did not make it the first time, and then somehow they retake the exam in 2023, but they graduated in the years before, then they're also not required to have CLEP. So again, the reckoning period of year of graduation 2023 and taking the bar in 2023 and onwards. So next is if they graduated 2019, but they did not take the 2019 bar, instead they deferred and took the bar in 2023, are they required to take the CLEP? Same answer. So even if they did not fail or they did not fail because they did not take the exam at all, they deferred it to a later date, and the later date would be 2023 bar and onwards. Still, the first question is, did they graduate in 2023? And because they didn't, they graduated before, so they're not required to take CLEP. So hopefully these situations would provide enough clarity that as long as a student, only the students who graduate in 2023 and take the bar starting 2023 and later are required to take CLEP. And all previous batches are not required to take CLEP. But obviously CLEP but obviously schools can still offer CLEP even to the batches of which this is not required. So it's like an add-on to their training. That's definitely welcome. That's not prohibited naman. It's just that we're talking about those who will be required and required to show their compliance. And this relates to the next question. What may be submitted as proof to show compliance of the CLEP requirement to take the 2023 bar exams? This is where it gets important to note these things on record, because according to the FAQs of the Supreme Court, the bar confidant will be looking at these should show that the student has taken a CLEP course. So as you know, the TOR should reflect accurately what is the official curriculum of the school. And the official curriculum of the school is the one recorded by the LEB. And this is where this is very important to report to the LEB what CLEP courses you have offered to your students, especially those who are taking the bar exams of which the CLEP is required. So for example, a school has decided to offer a CLEP in their practice court or in their summer apprenticeship program or in their natural and resources environmental law course. So if these things are CLEP courses and the student graduated having these CLEP courses, but this fact was not reported to the LEB, then the LEB will not be able to report to the OBC that this school has CLEP courses because the school did not report that fact. Now, the OBC may refer simply to the TOR, but they may also ask the LEB to verify and validate these information. And in that aspect, it's very important then for the school to report. And this is also one of the reasons why we have issued LEBMO number 23 for how schools can integrate the CLEP into their curriculum in the interim, and for the schools to report it to us, because that is where the public record will be annotated to show that the school really does have CLEP courses. So if you have questions about that, please raise your questions. So there's a question in the chat box. So meaning the following requirements must be present: graduate of AY 2022 to 2023 and taking the bar in 2023. Yes, Sir Ismael Sarangaya, both requirements should apply for the CLEP to be required of the student to take the bar. Otherwise, they are not required to take the bar. Okay, so let's move on then to how do we and how can schools report the CLEP courses that they have to the LEB. Can we move on to the next page, please? All right, so let's talk about the certification of LSP. So this is almost like the students, it's almost like new lawyers getting their license. So the certification of LEC is actually their limited license. And that's very important process because as much as lawyers need that ritual, need that process to be finished, it's also the same with LSPs. So first of all, does the school need to apply to the LEB to approve its curriculum before students get certified in court? The answer clearly is no. These are independent processes, meaning you can go ahead and you should go ahead and apply with the court for the certification of your students, and at the same time also deal with the recording process with the LEB. Right? So let me reiterate that you do not have to wait for the LEB to approve, certify, or act on the curriculum notation or recording before you ask for certification from court. If anything, please, if you still haven't, please certify your students with the court. So is the first year student eligible already to engage in limited practice of law? The answer po is no, because certification level number 1, the lower certification, already requires that the student must have completed their first year subjects. So they cannot obviously be eligible for that if they're still taking their first year law subjects. So they're at the minimum or at the earliest, they can take their certification during the summer term after the first 2 semesters of the first year if they already are certified to have completed all their courses there. Pag sabi po natin na completed, dapat po wala rin pong bagsak. Dapat po napasa po nila lahat ng kanilang mga subjects sa first year before they get the level 1 certification. And that also answers the question number 3, who can obtain level 1 certification. How about level 2? So level 2 naman po are those who are finishing their second semester in third year. So there's a difference here because even when they are still finishing their third year subjects, they can already be applied for a level 2 certification. So this is important because you don't have to wait for the level 2 certification you don't have to wait for the year level or the semester to be finished for you to apply law students in the certification. So halimbawa, tapos sa first year nila, pasala sila, second year pasala sila, third year pasala sa first sem, for second sem, they take pa sila. Pero pero pwede sila magpa-certify even if they are still taking on their second semester subjects. Ito po ay allowed under the Rule 138A. But meron din yung limitation, and later I'll talk about it. So when you practice under level 2 certification, if you already have gotten your certification and also are already enrolled in the CLEP course. So yun lang naman ang kailangan natin for our students to actually exercise their certification or their privilege to have limited law practice. They already secured their certification and they're enrolled in a CLEP course. So may question po dito si Dean Nita from Bulacan. Since students need to pass all of their subjects, are they required to have the minimum number of units on subjects taken and passed? Yes, Dean. So although the Supreme Court has said that it will be dependent on the school, so the Dean really will be the one exercising good faith in certifying their students have passed their subjects. But this means that the Dean or the school knows that the student has taken all of the expected subjects from those year levels. So for example, if you have a regular student, a first year regular student who was allowed to take their first year subjects later on, but the expectation is they should have taken that subject during their first year, they're still not qualified to have that certification. The same way sa level 2 certification, the student should be certified at that point where they have taken all of the expected number of units and subjects for a regular third year law student. The rationale for this is that that student is already, in the eyes of the school, that the student has taken all 3 year levels and therefore is qualified for a level 2 certification practice. So hindi po siya, ang point of reference po natin, hindi yung personal student circumstance na third year na siya pero irregular lang. Hindi po, ang ating point of reference po is yung school na in-expect niya pag third year, ito lang subject na tapos at naipasa. And therefore, they will now be able to certify the student who has taken all of those subjects and passed them to become level 2 certified students. So Palawan State says, can students be allowed to remain in certification level 1 until they graduate? So according to, and later I will touch upon this, in terms of effectivity of the rule. Actually, the point of reference here really is during their CLEP course. It's very important that their certification is really only relevant to their CLEP course. But I'm skipping a little bit. Let me just talk about that further later. But let me just do this other question. When can a level 2 certification be automatically revoked? So as I mentioned, even if the student is still taking on their second semester, third year classes, they can already be certified. However, at a later point, when the grades come in and the students did not pass some of the courses of their third year, second sem, then that certification also automatically revoked according to the Supreme Court. So again, this relates to the expectation that they should take all of the required subjects and pass them. So revoke automatically certification pag bumagsak po yung estudyante sa mga subjects na hindi pa na ng second sem, third year. Is level 1 certification prerequisite to level 2? Hindi po. They're separate. Even if essentially level 1 is a lower certification than level 2 in terms of the coverage of activities that may be done by the student, but they are not prerequisites to each other. You can have a school with only level 1 certification. You can have students with only level 2 certification. That's completely acceptable under the revised Rule 138A. And now the last question, how long is the activity of the certification issued in favor of lawsuit practitioner regardless if level 1 or 2? And answers the question of Palawan State. So very important po na CLEP is a very specific exercise, very specific activity. It's only in CLEP that the level certifications are relevant. Outside of it, hindi na po sila relevant. Meaning, the student after their CLEP course no longer enjoys or should no longer enjoy the privilege of limited student practice on the nature of their certification level. Well, I think the rationale here is that CLEP is very specific, that they should always be guided, that they should always have a supervising lawyer in all of their activities. And so that supervising lawyer as well only really functions in the context of CLEP as a course. So, ibig sabihin po kung hindi na po sila supervised, wala na po kayong program for them, hindi na po nila magagamit ang kanilang certification level. However, the school can design their curriculum to have a continuing CLEP from second year or from the earliest years to the graduation years. We already have a school. I've seen a school have CLEP all across the 4-year levels. And that means that their students can now exercise their certification all throughout that stay in law school because they're guided all throughout. So yun lang po ang ating point of reckoning. Kailangan po meron pa silang CLEP course para matuloy-tuloy po kanilang certification level na practice. Otherwise, hindi po nila yun magagamit. Let me see some of the questions. Si Sir Ismael, for instance, our school offers law and Christian values, which we intend to offer as an institutional course, even with the revised curriculum. Should the student finish even that subject to be able to secure level 1 certification? The safe answer, Sir Ismael, is yes. Because hindi po yung curriculum ng LEB, yung model curriculum, ang titingnan po natin to say a student has finished their first year. Ang titingnan po natin is yung school curriculum, yung school design curriculum. Bakit po? Kasi ang lahat po ng mga LSPs na nag-practice sa school nyo ay hindi lang po sila LSPs in general. Hindi lang po sila Filipino LSPs. Sila po ay law student practitioners ng school ninyo. And they will showcase what it means to be trained by your school. So their clients, their society will say, ito pala ang LSPs nang galing sa school ninyo. So for example, Christian values and law is something very integral to the design of your curriculum. It's something that you believe should have, that your graduates or students should have, then that should also be present in the training that the students will showcase in their level of certification. So the short answer is, opo, i-require niyo po sila na magkaroon ng ganitong course and dapat pumapasa nila yun para masabi po ninyo na kumpleto sila sa kanilang first year. So hopefully that makes sense po. It's still the it's still the school curriculum that is the reference point. Hindi po yung minimum curriculum ng lab. So very important po yun makita. And for some schools, ang kanilang institutional requirements, even if it's religious in nature, formation in nature, they integrate that. Parang parte po siya sa training ng kanilang LSPs. Para sigurado po nila ang kanilang LSPs ay may correct values, may formation, ethical formation, etc. So I'm sure it's going to work out in sir, for the benefit of the students. All right, so if there are no more questions, but again, if you do have questions later on, please put them out. No more questions on the certification of LSPs. We can move on to the certification with LED. Sir Danny asks, what is required at least 2 years of CLEP? What about the levels 1 and 2 certifications? Are they required for students to satisfy the requirements for the CLEP course? Yes po, kasi po Sir Danny, ang CLEP po ay may dalawang aspeto. Ang first aspect is the practice or the practical learning or the practical experiential learning, but the other aspect really is the classroom setting as well, or the reflection and the discussion aspect as well. So ibig sabihin, CLEP is just the course, but for them to actually practice, they have to have certification. So it's in tandem. They have a CLEP, they learn about stuff, they're taught about stuff, and they experience the stuff, but they also have the privilege through a certification. Without the certification, they're just learning, they're not practicing. But also when they're practicing with a certification, but they don't have a CLEP course, then that's not allowed as well in the rules of course. So very important po na either they have 1 or 2 when they have their CLEP. Okay, so particular concern came up last night when those students is presently overseas from Sir Clark. He wants to take CLEP but cannot apply for certification because he is not in the Philippines unless his application is consularized. And either way, he cannot do limited practice in the PH. Is there a work around this? So Sir Clark, this is a very, very specific and unique question. So I won't be able to answer yours substantially now, but maybe our team can contact you so that we can meet with you one-on-one. Is that okay? That we'll be able to deconstruct this question. Tama nga naman, your student is not in the Philippines, but they're taking their course. But there's a complication in their application and eventually their practice. So okay lang po ba, Sir Clark? We can talk with you one-on-one, and then whatever we find out in your concern, we can actually share to other schools who may face the same problem. All right, so sir. From Philippine Christian University. We'll take note, sir, of your email. Okay, so I think before we go on to and thank you very much for the questions. It's really important to have these kinds of opportunities because we're seeing a lot of concerns. Before we continue, I guess Gab will now provide first for us a wellness break so that we can digest some of these questions. All right, thank you, Gab. I hope everyone had a short but nice break. So before we continue, I'd like to just recognize there are a lot of people in the room. We're happy to have you here. We have our stakeholders, we have North Luzon, we have Southern Luzon, a lot of them. We have from Eastern Visayas, and we have from Western Mindanao, as well as Northern Mindanao. So hi, everyone, again, good morning. We're having our town hall meeting today to discuss, freely discuss concerns about CLEP. And we're also happy to have here our friends from Asia Foundation, as well as from the Embassy and INL. Hi, Attorney Shadney. Good morning, everyone, again. Okay, so I'd like to continue now the discussion on the process naman po for having your curriculum certified or recorded by the LEB. So next slide, please. And we've heard that there are challenges or schools certainly sometimes have concerns about certification with the LEB. All right, sorry. Before we get into the LEB, there are other questions that you may be interested to know about certification for LSPs. All right, so how much does it cost to apply for certification of students? According to the Supreme Court, it's just 200 pesos under Rule 141. Then should law school endorse an application for certification individually? The Supreme Court suggests or greatly encourages the school to submit the applications in bulk or in batches instead of having the students apply individually. Is the applicant required to submit a certificate of good moral character for their certification? Strictly, no. They're not required to have that certificate for them to be an applicant to be certified. The Supreme Court mentions that by the dean certifying the student or endorsing the student for their application already assumes that their good moral character has been also certified, but it's not, you're not prevented from attaching that certification as well. Where shall all those applications be submitted? All applications should be submitted through and to the executive judge of the the judicial region where the school is located or where the student is expected to practice. However, the one who approves level 1 certification is the executive judge, but for level 2 certification, the executive judge endorses this to the appropriate the court administrator to certify or approve the certification of the level 2 certification of students. When may a law school practitioner take the oath? After the certification has been issued and after the school has coordinated with the local court, with the local executive judge for them to take the oath. And yes, the law student practitioner can only take their oath before the executive judge who issued the certification and no other person, even if those persons may be authorized to give oaths. So only the executive judge of the region that where you have that certification issued. Okay, so if there are no more questions here, let's move on again to the certification process or the application process for the curriculum integration in LEP. It's very important before anything to say that the certification for LEB's certification is really to assist schools in putting in the public record how they have integrated CLEP in their curriculum. Let me just skip the second question. Is CLEP a standalone course? The answer of the Supreme Court is yes. So the CLEP course must be standalone. But the Supreme Court also said that in the interim, the transition period, offering a CLEP, not a standalone course, can be acceptable, but it must be integrated or substituted in specific subjects or in subjects under the curriculum. And this is where the LEP process comes in. We are helping and facilitating schools who are not ready to provide standalone courses to integrate CLEP into their curriculum as it is. So definitely, the school does not need to submit a list of students when they're applying for the curriculum recording or notation in LEB. It's just that they have to apply for that. So number 3 question, what existing course may be replaced by CLEP? The Supreme Court mentioned a number of subjects like practice part 1 and 2, legal counseling and social responsibility, summer apprenticeship programs. So this may also be offered, or the CLEP may be offered in lieu of or a substitute to these courses because they're a bit related, although they're not the same. But the CLEP can also be integrated into existing courses. The LEP has taken a very open and facilitative approach that you can embed CLEP in almost all of our courses. And when you embed CLEP into those courses, you embed clinical or experiential learning methods in your existing courses. For example, in alternative dispute resolution course, in the environment course, in the in the environment course, for example, when you your students to do certain education activities, for example, or do certain pleadings while they're in their environmental course. So yes, you can also integrate and embed these CLEP into these courses allowed in LEB for schools to actually offer application form when you submit it to us which only means which only asks schools to say, how have you integrated CLEP into your course between 2020, 2021, 2022. And the schools only need to report to us whether they just integrated CLEP into an existing course, such as offering CLEP methods and aspects or elements into a course.
Attorney A, can you hear us? Can you hear me?
Hi, sorry, I think I got cut from the meeting.
Continue.
Can you hear me now?
Yes, please.
Yes, we do.
All right. Thank you. Apologies for that. Where was I? All right. Maybe I can remove my video in the meantime, just to make sure it doesn't happen again, hopefully. So anyway, so moving on. So yes, as I mentioned, the school only has to report to the LEB what mode you have chosen to integrate your CLEP. For example, is it through integration when you have, or is it substitution where you have offered a CLEP and removed or will no longer offer another the subject. And finally, if you would want to offer a standalone course, in
Apologies for the technical difficulties. We're experiencing a bad internet connection. Maybe we can give a few minutes for Attorney Aaron to reconnect. Thank you very much for your understanding.
Hi everyone. Okay, I'll just have a laugh at our technical glitches. I apologize on behalf of the LEB. Hopefully you're still with us here. All right. To continue, I think we have a question on the chat from Dean Lares. Good morning. In case of CLEP integration, are the students enrolled in the course required to secure level 1 or 2 certification for executive judge? Salamat po. Yes, ma'am. So even if you quote unquote just integrated your CLEP into a course, it's still a full-fledged CLEP course. It's still considered as your CLEP compliance. So that means that, as I mentioned before, the CLEP compliance should be partnered with the certification process of your students. So Integrating po, substituting the subject is just a very facilitative way so that you can now have CLEP even if you're not ready to have a full-fledged course. A standalone course. But that also means any mode of this CLEP is still CLEP and the student is required to have a certification. Thank you din po, Dean. All right, so and last question here is how many units or hours should be given to CLEP? So as I mentioned before, it's only 2 units at the minimum. That's expectation of the Supreme Court. And in the revised model law curriculum, which is going to be mandatorily applied starting this incoming school year 2022-2023, CLEP is already a standalone course. So in the interim between 2020 to 2022, it can be at the minimum just 2 hours. But actually, to be perfectly honest, we are not applying a minimum requirement as far as the LEB is concerned. But just to be on the safe side, we recommend that a minimum of 2 units also is offered by the school because that's the number of units that the Supreme Court had also identified. Ayun po, sana po nakalalawan po tayo in terms of the curriculum process. Kami po ay pupunta po sa inyo virtually kung kayo po ay nahihirapan pagdating sa process sa LEB. Gusto po namin tulungan kayo na ma-make sure na pagtapos itong taon na to ng 2022 na academic year ay nailagay na po natin, record na po natin sa LEB ang lahat ng inyong CLEP activities simula ng 2020 para po pag nag-bar na po yung students at kami po ay tinanong ng OBC, OBC comes to us and asks, has the school reported or officially have their CLEP course? We will be able to say yes, all schools have had their CLEP during that period. Okay, so we encourage you please to contact us. Please send us your application. Even just a simple letter explaining to us how you integrated CLEP will suffice already, and that can also trigger our own response. We can come to you, we can talk to you, and help you further in this process. All right. Sige, maybe we can move on to the next topic, please. All right. So as I mentioned, there are ways to there are different ways to offer CLEP and different models and methods to do it. Just to touch on what Dean Sol asked about, do we need the LEB's approval? So strictly no. So actually, this is the beauty or the flexibility that LEB has given to schools. You can actually report to us retroactively. So for example, you have been doing CLEP already since 2020, 2021, but you're reporting to LEB only this year. That's perfectly fine. That's okay with us. We just want that aspect or that fact to be recorded to us. That's why even if sometimes we refer to it as an approval process, really essentially it's more of a recording process so that we can really put on public record that these activities have been conducted by your school. So these all know po, you don't need our approval to have the CLEP, to apply it, to implement it, but we do need that on record. And I think you already have that on record from your school. Palawan State asks, if the school does not have a law clinic for internship, can we offer externship only with partners? So I will answer that question po from the Palawan State through these different questions. Dean Sol has a follow-up question. Do we need to provide the specifics of our school's CLEP? No, Dean Sol. Only when I mean report to us the activities, I only really refer to the CLEP, the curriculum, where the CLEP is integrated or shown. All right, you're welcome po, Dean. Okay, so to touch on what the Palawan State asked about externship, internship, etc. So what is the difference first between apprenticeship and CLEP? So apprenticeship kasi under our old curriculum is really just going to and shadowing or sometimes working on the job with current lawyers or current agencies. CLEP is specifically designed. There are many aspects to CLEP, but very essentially, CLEP is specifically designed for the contribution to social justice and society. So that's very important to note. Meron po siyang ganung inclination or focus at meron pong specifics in terms of structure and type of learning na expected of student inside the class. So usually po kasi apprenticeship, the student is asked to go in a way in an external office and then provide work hours there and perhaps submit a paper at the end. It's very different in CLEP where the students should be guided all throughout the process, depending on the nature of the work assigned to them. So number two, can I take CLEP 1 and 2 simultaneously? The safe answer is no, I think. So we haven't had faced this problem before because it's practically new, but our advice is not to take it simultaneously because they have different natures. Particularly, not natures, but a student shouldn't really have to enroll in two CLEP courses at the same time. They should only take one CLEP course and that's it. Sorry, in a semester. But this is not preventing any school from designing their CLEP in a very creative or innovative way. So yes, just to be clear, no, CLEP 1 and CLEP 2 refers to the course, not the certification. So you can have CLEP 2 course or CLEP 3 or CLEP 4, CLEP 5 course and still be on a certain level or certification, depending on what the school wants to have. Um, I already took my apprenticeship program prior to the issuance of CLEP. Shall enroll again for a CLEP subject? Yes po. This is where that distinction happens because an apprenticeship, an OJT training, a law clinic training even, before the CLEP rule was applied is different when under the revised Rule 138A. Opo, yun po yung isang distinction na gusto pong i-highlight natin sa rule na kailangan pong student ay officially nag-enroll sa isang CLEP course at officially nakuha siyang certification para po ma-fulfill niya yung compliance na required of them for the bar examinations. Very important po yun. So hindi po pwede yung previous course, previous experience, tapos i-apply po yun as CLEP. Hindi po yun pwede. Kailangan po dalawang bagay ang nangyari. Sila po ay na-certify, either level 1 or level 2, at sila po ay nakapag-enroll at natapos ang CLEP course. What are the components of the clinical legal education program? And this is something that would give that further root. Ang CLEP po kasi ay dalawang aspeto, yung clinic portion at yung classroom portion. Ang clinic portion po, yun po yung sitwasyon or yun po yung aspect of their education that they actually practice. They actually go and discuss matters with their client. They go and serve communities or organizations. They go and serve organizations or government offices. So yung clinic aspect. But there's also a classroom aspect. At dito po pasok yung supervising lawyers natin. But students must, in how they experience the practical knowledge or practical skills, they must be able to reflect on these experiences. They must be able to understand what they're doing, gain knowledge from it, and hopefully hone their professional skills. So tandem po sila, hindi lang po sila nagtututo kung paano gawin ang mga bagay-bagay, naiintindihan po nila at yung mayabong po or nag-improve or nag-develop po ang kanilang pagiging lawyers in the future. So very important po yung experiential aspect po to it, both the classroom and the clinic aspect. At dun po wala po, for example, sa practice court, trial technique, and the similar subjects. Dito po minsan skills lang po ating pinibuild. Matuto lang po paano mag-advocate, matuto lang po paano magsulat ng pleadings, matuto lang po kung ano ginagawa sa korte. Iba po yon sa naiintindihan po nilang kanilang role bilang lawyers, na pag-iisipan po nilang ang mga ethical considerations na kanilang ginagawa. Naiintindihan po nila yung katotohanan sa ating lipunan, pagdating sa social issues, pagdating sa mga challenges ng ating mga indigents, pagdating sa access to justice, etc. etc. Yung po ang mas mayabong pagpapayabong ng CLEP para po maging lawyers po sila, hindi lang po sila maging marunong at magaling, kundi sila po ay may puso, may isipan na nahubog po natin through this formation sa CLEP. Does a law student practitioner need to perform all the practice areas under the rule? Hindi rin po. So, depende po actually yan sa school. At ito po yung minasyon po kanina na nakadepende po sa school kung level 1 or level 2 ang kanilang i-offer. Hindi po required na both i-offer ng school. Pwede po na level 1 lang po ang pagawin ng school sa kanyang mga students at pwede po specific lang po na aspects ng level 1 ang gawin nila. Hindi po required ng school na explore lahat ng mga things that are enumerated under the law. But on the other hand, the school can also be innovative and can also actually experiment with all of the different different activities under CLEP. If they feel that they're confident to do it, they feel that the students will learn more, if they have a variety of activities that they can choose from or will undergo, that's also depending on the school's academic design and discretion. The specific item here is that sometimes may be confusing to our schools and the students is what does it mean for LSPs to negotiate for and on behalf of the client. So the court said that, or the Supreme Court said in the FAQs that this really just pertains to that our students are also allowed or can participate in ADR, in alternative modes of dispute resolution. So that's another aspect to their training that the school may want to offer. Next, please. Does CLEP only cater to marginalized clients? So as I mentioned before, meron tayong merong intention ng rule, merong inclination ng rule to help the marginalized, but it's not. But strictly speaking, the CLEP is not limited to them. But this is a very specific exception or addition to what the CLEP can do. They can only really serve other than the marginalized government agencies because it's rooted in the promotion of social justice and access to justice, etc. So as long as you're helping government as well do its job in terms of building a just and humane society, all of these are rooted in the same values that CLEP also wants to build among its future legal professionals. So yun po, specifically, gusto natin marginalize ang clients natin, but the LSPs can also serve through externship local government government agencies. Can law student practice engage in legal activities nationwide? Dahil po may limitation ang ating certification na sa executive judge tayo mag-apply, ibig sabihin po sa judicial region lang po kung nasaan naka-assign yung executive judge, pwede mag-practice ang students din. So hindi po pwede, for example, a law student in Northern Mindanao can practice in Visayas. Hindi po pwede na ang ating student from Bicol can practice an NCR case, etc. etc. So limited din po siya, especially sa level 1 certification, kung saan naka-assign din po ang executive judge na nag-issue ng certification for the students. How about level 2 certifications that now touch on participating, appearing, filing pleadings before the Court of Appeals, the Court of Tax Appeals, and the other collegiate courts. So pwede rin po actually, pwede rin po mag-participate itong students, pero kailangan po leave of court. Yung po important aspect here that for the collegiate courts, especially CA, CTA, Sandigan, and Supreme Court, the students must, the LSPs must secure first leave of court before they can actually participate and practice here. So let me now touch upon another aspect of another model, which is externship. And this will finally answer, I hope, the question of Palawan State is that, is externship the same as internship? No. According to the FAQs, internship, in a sense, is, at least in the context of CLEP, internship means a student practices within the law clinic. But externship means the student practices outside of the law clinic in external organizations or agencies. So yung po yung distinction ng ating externship and internship in the framework of CLEP. Where may externships be done? The Supreme Court identified certain organizations or agencies, for example, in the IBP, in the local courts, in the local justice actors such as the DOJ, but also other agencies that would, or local government units that would be benefited by the externship practice of our students. So allowed po yun. And pwede po tayong mag-participate or makipag-partner sa kanila. So sabi po ng Palawan State again, kung ang school po nag-opt lang po ng externship, pwede po ba yun? Pwede po. Allowed po na ang school, externship lang po yung kanyang CLEP design para po sa kanyang CLEP program. Pero very important pa rin po na yung requirement for having a law clinic should be met. by the school. So even if po externship lang po ang ating ino-offer at a certain time for our students, kailangan pa rin po ng CLEP, kailangan pa rin po ng law clinic. Why are private practices law office excluded in the permitted areas of externship? Sabi po ng Supreme Court, kasi po ang ating focus ay yung access to justice ng ating marginalized clients at for social justice concerns. So hindi po pumapasok dito sa category na to ang private law offices. For sabi naman po ng ating Supreme Court, outside of the CLEP, the school can still provide their students opportunities to actually have private law office experience, but outside of CLEP. Oh, right. Next question, please. Next slide, please. Hi, Attorney Warren. He has a question. Can we place our LSPs at government agencies outside the jurisdiction where the law school is located? Attorney Warren, I think the safe answer is no. Government agencies, the LSPs must also practice within the region where their executive judge is sitting. So that's the safe answer. But don't worry, Attorney Warren, I think you have an important question. Maybe we could ask the Supreme Court, ask our partners for further clarification, and we can talk about it one-on-one and share the answer to other schools. But right now, our safe advice would be to limit them to the jurisdiction where the school is located. Sir Danny also asks, are there existing arrangements with courts and offices where decisions can be had, or is it law schools which are expected to do the arrangements? Sir Danny, the general answer is yes. It's the law schools which are actually expected to make those arrangements happen. Later, we'll have a best practice that we can share to you from one of our schools, so you can see how they've done it. But yes, the law schools are expected to do the arrangement. However, the Supreme Court has specific externship rules for their local courts. So as far as we are concerned, the local courts already have a mechanism for this externship to happen. So please do contact the local courts you have and ask them about the externship rules or the externship process that they have Supreme Court issued, and hopefully that will be something that you can tap. Okay. So next few questions. Can an existing clinic continue to operate under the CLEP? Yes. We have had law clinics before CLEP, and they can still be the same clinics under CLEP. Is it mandatory to have a physical office for the law clinic? Now, this is the answer of the Supreme Court. The Supreme Court said yes. There's an expectation that the law clinic must have a physical office eventually. The Supreme Court did not say that we can have. Actually, the Supreme Court also encouraged virtual law clinics during the pandemic and this transition period, but the expectation is still at some point the school must invest in their own physical law clinic. However, that law clinic doesn't have to be the biggest or the grandest type of office. It could be a simple desk, a simple area in your law school that can serve as the law clinic. That's perfectly acceptable. So there's no minimum requirement as of this time in terms of how big the law clinic is. But physically speaking, yes, the law clinics must exist as an office at some point. Who shoulders expense incurred during the CLEP operations? It's the school that shoulders expense of CLEP. And the school obviously can defray these costs from tuition fees and other fees that students pay or other donations that it receives. But the cases that the school actually handles, these cases, they do not have to pay the fees related to these cases. The clients are still expected to shoulder those expenses. Is there a maximum number of law clinics that the law school can establish? No. Actually, that's something that maybe is lost to some of our schools, that there could be many law clinics the school can offer. A law clinic focusing on one aspect of law, another field of law, etc. One offering one offering internships on different specialization. That's also something that you can actually do. Are law clinics required to specialize? The answer is also no. There's also no pressure to schools to specialize. So you can also be a general practitioner of sorts as a law clinic. You can offer a variety of different services and different aspects of law, but you can also choose a specific aspect of law perhaps depending on who your supervising lawyer is, on what the values and direction your school has, etc. So those are other considerations, but you're not expected to specialize. Is it required for the school to have a clinical legal education program head or director? The Supreme Court expects us to all have our own CLEP head or directors. So that's very important. The Supreme Court wants to see that schools are committed to CLEP, so, and as well as the LEB. So we want to have you to designate your own head or director for your CLEP. However, you don't have to hire another person for this. You can assign one of your faculty members or your administrators to be the program head or director. That's perfectly fine. And is there a need to accredit law clinics? The answer is also no, because all schools are expected to have law clinics, so there is no need for another accreditation process specifically for your clinics. Next slide, please. Is there a required organizational structure for law clinics? Not really, Dean. It's just that there are certain people are expected to be there, particularly the CLEP, program head or director, as well as the supervising lawyers or lawyer, and then the law student. So those three persons are the only structure required. But more than that, you can definitely develop your own structure. Is the law school, speaking of supervising lawyers, is the law school required to hire appoint a supervising lawyer? Yes. The law school is expected to have at least one supervising lawyer for its LSPs. But the supervising lawyer does not have to be a member of the faculty. They can be practitioners engaged specifically for the purpose of supervising students under the CLEP. And the question earlier about whether the lawyers in the agencies where the school is sending externs to can be supervising lawyers, the answer could be yes. They can be the supervising lawyers as long as the school have formally engaged them specifically for this process. So kailangan po may intent din po tayo. Pero hindi po kailangan na i-hire po natin supervising lawyers as new faculty members. Does the provision of a supervising lawyer entail actual physical presence during the performance of any of the activities enumerated? It depends on activities. For level 2 certification activities, for appearances in court, on level 2 certifications, yes, the supervising lawyer is expected to be there. For level 1 appearances in court, pursuant to level 1 certification, rather, the supervising lawyer is expected to be there only when the judge asks them to be there. So depende po kay judge kung in-expect po niya nandun din yung supervising lawyer. And finally, for all other activities, hindi na po kailangan all the time nandun yung supervising lawyer. Nasa discretion na po niya kung gusto niya pa sumama or bantayan ng kanyang students. But definitely, even during the times when the supervising lawyer is not around, they must be able to supervise and review the activities and actions of their students after they have done their activities. Is there a required number of years in practice for supervising lawyers? No po. Even a fresh graduate, a fresh lawyer can be a supervising lawyer, but the qualifications would depend on what the school would require of their supervising lawyers. So school po ang bahala. Can supervising lawyers supervise students from 2 or more clinics? Yes din po. They can be supervising lawyers not just in one school, but in many schools. But here's the important aspect here, and this relates to how many student practitioners can a supervising lawyer handle at any given semester. The answer to both questions is hanggang as long as the supervising lawyer can competently supervise them. So wala pong binigay na number ang Supreme Court on how many schools, how many students can one lawyer handle. It should be based on how they can competently handle it. It's very important po, our dear schools, kasi kung halimbawa po at some point makita po na too much ang binigay sa kanya or ang kanyang ina-handle, that could mean also liability, perhaps a school, but definitely sa lawyer who took so much on. What is the nature of the liability of supervising lawyer in case of negligence? At yun pong minention ko, they will be judged based on the canons. So their professional responsibility will be judged by the Supreme Court if ever they have failed in supervising competently any of their LSPs. So yes, it is a very serious job. There's our serious responsibilities. But I have heard then po that is very fulfilling. It's something that many supervising lawyers, even non-teachers, people who don't regularly teach, they find something fulfilling as well in being a supervising lawyer. And just to differentiate further, what the term that they call a podium law professor is the one who usually lectures inside the classroom, does lectures, seminars, presentations, but really more on theoretical aspect of things. While a clinical law professor or clinician is somebody who may not teach normally, but is guiding students in terms of their practical knowledge and reflecting on their limited professional practice. And finally, what are the qualifications for a clinician? A clinician is expected, according to the Supreme Court, to have specialized training on pedagogy and on experiential learning. And fret not, LEB has been giving a lot of trainings together with the support of TAF and our stakeholders, a lot of training on clinical pedagogy and handling operations for the law clinic and CLEP itself. So these are available po on our LMS and on our specific YouTube channel. If you have any of your supervising lawyers, new supervising lawyers, you're having a hard time explaining or onboarding them, or you're looking for training for them, please contact us. They can go through our course, they can go through our videos, we can help them be ready to be supervising lawyers. All right. Last, can we go on, please? So just as a final set of questions for today. So we know that there are still continuing concerns of students in terms of complying with CLEP. So here are some of the questions we have faced. I'm a government employee and a law student. May I undertake my CLEP under my government agency I employed at? The answer is no. It's very important po, and Chief Justice Alexander Mundo emphasized this, that there should be nothing in return for the students when they undergo CLEP or they serve under CLEP. Wala po dapat something that they get from it. Not something in kind or monetary, financial from it. So if a student is already earning or is part of their job to be there, that cannot be understood as CLEP. Dapat po outside of it, something that is voluntary and pro bono. So hindi po pwede na nag-work na po ako sa court as a student, pwede pa dito na ako mag-extern, hindi po yun allowed. Nag-work na po ako sa PAW as a paralegal, pwede po ba ako dito mag-serve for my CLEP? Hindi rin po pwede yun. Kailangan po sa labas ng kanilang trabaho or sa labas ng any gainful employment or already something that they're already doing. Because they're getting paid for it. If the agency or company that accepted me to take CLEP for externship decided to pay my service, will I be allowed to take it? The safe answer po and our advice is no, please do not take it. Because pro bono po ang nature ng ating CLEP. So it doesn't mean that you're not supposed to accept, students are not supposed to accept any kind of support from their agencies. If, for example, they take care of their externs, they feed them, they give them additional support, etc. That's not naman po prohibited, but to be paid for the service is a different discussion of the matter. And we must emphasize that the heart and spirit of CLEP should be pro bono service, something that we want to inculcate among our law students. But then the question would be, how about the working students who are working and might be having a hard time? So this is where different models of CLEP can work. On one hand, they can provide support or services out after office hours or during weekends. You can offer clinic hours naman outside of the 8 to 5 frame and Monday to Friday. So your law clinic can be open during Saturdays for your working students or after 5 for them as well. At the same time, there are other modes of clinical service here. And that's something very important. CLEP actually provides for developmental legal aid as something that you can do for your law clinic. Developmental legal aid means going to communities, teaching, providing awareness programs, providing community clinics, actually going to people who are in jails for persons deprived of liberty, etc. You have a lot of other aspects of law and legal aid that you don't have to practice in court. And in these activities where you go to communities, you partner with NGOs, you have law students acting as lawyers to help those who are disadvantaged in life and in society. This can be done during weekends, and this can be done by working students as well. Can a lawsuit practitioner sign using an alias and initials? No, they have to sign using their full name and that name that is in their certification. And finally, if for some reason they have conducted themselves unbecomingly or have conducted unauthorized practice of law, for example, their certifications have been revoked, but they still practice law, or they have not undergone CLEP, but they are practicing limitedly as lawyers. So they will definitely be judged based on the same standards as lawyers. So even if they're just limited lawyer or limited practice lawyers, they're gonna be judged based on the canons of professional responsibility for lawyers. And in that sense, their certifications can be revoked, but also they can be barred from taking the bar for a period of years, depending on the Supreme Court. Okay, so my time is up. I exceeded a few minutes, but I hope I can answer some other questions. Yes, this recording will be provided to all our schools that you will be able to share it to your students and your other stakeholders. What else are we missing here? Yeah, I think we covered all the questions. Yeah, and thank you to Jojo for helping me answer them. So if you do have more questions, we have an open forum at the end. But at this point, I'll finish my talk, and now let's listen to schools who will offer their examples of how they did it. Hopefully that helps you as well. Thank you very much.